Brazilian authority is dealing with this topic. So nice to meet you, everyone.
Hello,
Burak? Yeah.
Burak. Thank you, Debbie and Henry, for accepting our invitation. It's such a pleasure to have the one of the best voices, thought leaders of privacy. As Efilli, we are really honored to have you both. And I am a privacy lawyer from Turkey. I am currently acting as a chief privacy officer of Efilli, which is a privacy tech company that has several consent management and other related products. Uh, right now, I am currently based in Netherlands, so I am very much familiar with the GDPR space as well. So I will try to do my best to contribute uh, from both Turkish and GDPR legal landscape perspectives.
Thank you so much. Well, I'm going to really enjoy this. So, as many of us know who are in the data space and in the privacy and data protection space, there's been just a lot of activity happening in privacy and data protection, especially since the General Data Protection Regulation was enacted and gone into full force in 2018. Obviously, some jurisdictions have had data protection and regulation before that, but because of GDPR, that's why I think a lot of companies and jurisdictions have looked very heavily at, what are their own data practices. So today, I would love very much for Henry and Burak to be able to talk about some of the key challenges and milestones in the evolution of privacy regulations in Brazil and Turkey. So I'll start with Henry first.
Yeah, thank you, Deb. Well, first, before our general data protection law, we call it LGPD. We had like a path through this law. We had previous of that our federal constitution guaranteed fundamental rights such as privacy, but more focused on the intimacy, honor, image, and secrecy of correspondence. Not like a broad general data protection law. And we had like a few milestones here in Brazil that help us to start to build our the LGPD and help us to create a more mature landscape focused on privacy. And the first one is, of course, the global influence of GDPR. So when GDPR started to be reviewed in 2012 or 13, if I'm not wrong, this was the same time that our first broad bill was discussed in our Congress. Then when the GDPR will start to enter into force in 2018, this discussion, of course, helped Brazil to gain momentum on discussion of our law. There was also a lot of public debates around this legislation, but the pinnacle of this was the Cambridge Analytica. So in the beginning of 2018, I don't know if you all remember, but the Cambridge Analytica was a big scandal at the time, and the Brazilian president and also a few CEOs of big Brazilian companies were alleged being spied by NSA. So this started a public movement, and the public opinion was asking for something that could prevent this to happen. And that was sorry, I mixed the subjects. I was talking about Cambridge Analytica and then went to Snowden. Sorry, but Cambridge Analytica was using data to manipulate elections around the world, or alleged manipulate election around the world. And we were in a year of election in Brazil, so the public opinion was focused on how we can prevent this kind of stuff to happen here in Brazil. this was all the context that preceded LGPD to be approved in Brazil. In 2018, we have the approval of the law. The law came into effect in September of 2020. We had 2 years of vacation legis before the law came into effect. The penalties of the law entered into effect only in 2021, also almost 1 year after the law was entered into effect. And our data protection regulator, our data privacy supervisor, the Autoridade Nacional de Proteção de Dados, we call here ANPD. She was the authority was created in 2021. So formally 2020, but in the end of the year, so 2021 was the year that our data protection authority was really formally structured. So you had like 4 years. Almost 4 years of an authority working in regulations and enforcement actions and guidelines. We're kind of a baby, if you can say that, regarding the maturity of this topic in Brazil. And I believe that we can discuss, of course, later how this impacted all the cookies and behavior advertising topic. But this is the current state of the law in Brazil.
Very good. Thank you. Barack, you tell me what's happening in Turkey.
In Turkey, the situation is a bit more, let's say, more mature than what Henry mentioned about Brazil in terms of time, because in 2016, when GDPR was accepted in EU, at the same very similar period, our law was also accepted, but frankly, our law was the translation of the previous European directive, not GDPR itself. So we had some sort of chance to grasp it with the latest version at that time, but we couldn't do it. I don't know, some political reasons, some other reasons. It's not my field. But what I can say as a privacy lawyer, in the end, we had a European founded mindset being brought into Turkish legal framework, and in the end, it had some. It's always like that. We generally, as Turks, get highly influenced by European, especially legal frameworks. But in the end, always the operation side, the implementation side is Turkish. So we have a Turkish way of implementing European values. I think Henry would also feel a similar thing about his country, because
Of course.
in the end, GDPR is a European mindset, and this data protection is a most Western way of looking at things. But in the end, we had our data protection authority was full in force and was able to give some verdicts about general data protection matters since I think 2018. So it's almost like it's more than 5 years now. It's almost 10, somewhere around. We are in between. So we can say that now there is a maturity in Turkish data privacy, data protection space, where we have lawyers, we have academics, we have papers, we have privacy tech companies like Efilli that I'm representing. So we have players in from every level, and some of them are currently great representatives of Turkish data protection space in the world. We have some academics in different universities. There are several startups operating in privacy tech, like Efilli in the global arena. So what I can say is it takes time, but I think Turkey passed the time, like it's on track.
Can I
Very
just
good.
make
Go
a
ahead.
quick comment here? I forgot to mention that as Burak brought here around the Turkish law, the Brazilian one was also heavily inspired by GDPR. It's not a copy and paste law, but it is of course heavily inspired. And one thing that we brought to this to our regulation from GDPR was the risk-based approach, which is something really new for the Brazilian regulatory landscape. It's not that the first regulation in Brazil with a risk-based approach, but I'm pretty sure that's the first one that have a comprehensive application. So, for example, at the financial institutions, everyone was more used to deal with risk-based regulations, but for other areas, it's not so common. And this is probably one of the biggest challenges that we have. We were more used to deal with I don't know the term in English. I believe that is rights and obligations approach, like a prescriptive law. When you have to do this, you have to do that. You cannot do this. And LGPD is not like this. GDPR is not like this, right? You have like a big way to measure your risk and take actions or make decisions based on these risks. And LGPD works in a similar way, which is a big challenge for the Brazilian companies to adapt with that, to understand this concept. We are at now we know how to deal with that, but I believe that the past 5 years, this was one of the biggest challenges and is connected with what we're discussing here about cookies, because sometimes I have to understand which risk I have in this data process activity when I'm doing, for example, behavior advertising, and this will indicate what kind of legal base I will use, how I will address transparency issues. So this is, sorry, I forgot to mention that. I believe that is important because this is a problem, also a maturity problem that we had in the past, and now I believe that is we are in a better shape to deal with this kind of discussions.
Very good. I like that. I like the distinctions to be able to, I feel like a lot of people don't understand that. So a lot of the nuance that you're giving is very important. Before we go on, I want to do a little bit of a technical segue, and I want to talk a little bit about cookies, how they track, store, and manage data. I hope that everyone who's on this call knows what cookies are, but I'll talk about it just briefly in terms of what it means, what they do, what it means, and then some of the other tracking things that people need to be concerned about. So if you have not been on the internet at all ever, certain websites that you go to or certain things that you do on the internet may provide you with a banner or some type of notice where they're saying, hey, we're going to collect data for XYZ purpose. They may ask you to accept or reject. They may ask you to, modify or create some type of action before you look at a website. And so what cookies were created for initially was to be able to have settings when people go to, or save people's settings when they go to websites. So for example, let's say, for instance, you wanted to go to a website and you wanted, every time you go to this website, maybe there's a certain page that you wanted or a certain way that you wanted to view it. That was really initially what cookies were built for. And so you may go to websites now and they may give you an option for necessary cookies, and that's what they mean. So that was kind of the original purpose of cookies. At some point, the advertising and ad tech agencies sort of hijacked what cookies can do. So they did kind of a ride along where they were able to, when someone went to a website, instead of the website just using their browser and their information just to give them settings and things like that, they were able to drop information on people's computers and also share data amongst other advertisers. And so that's where this big ad tech system or ecosystem has come from, where these companies are taking data about people and selling it and sharing it. So a lot of the legislation or a lot of the lawsuits around cookies are basically around that. So around, hey, I go to a website, you either drop some data on my computer or you take some data from me, and a lot of people weren't clear on what that meant or what was being done with that data, and so that's where we get kind of this cookie industry. I think the challenge going forward, and this is something I've always been kind of concerned about, and so to me, a cookie is kind of a mode of transportation. Okay, so it's a way to get data back and forth, and that process is not transparent as it should be, and often people don't get the choices that they should have when they're interacting on the internet with different websites. The bigger challenge I think that we have around this is that cookies have become like a poster child for this kind of unauthorized data sharing. But cookies are not the only way that happens. So I think especially as it relates to people who do data privacy and data protection, thinking about what these other mechanisms are, whether that be fingerprinting, some type of, browser scraping, there are a multitude of different things that can happen that don't require cookies, that essentially do the thing that people didn't want cookies to do, which is taking people's data or grabbing information about them or their browser or how they use computers or sites that they look at without their consent or control. So I think that's the high point there. So can you give me, I want to start with Henry, can you give me some real world examples of cookie compliance and best practices in Brazil?
Of course. Before I direct address your question, Libby, it's important to mention that our data protection authority published a few guidelines regarding cookies, and there is a few topics addressed here at these guidelines that personally I believe that our data protection authority look at more about what we have in the e-privacy directive, for example, how Europe deal with this topic, instead of try to build our own way to address this problem. And I'm saying that because, for example, our legislation have a legal basis called legitimate interest. Is almost the same that we have in GDPR, and we of course also have consent. And as you probably know, and I believe that our audience also know, the e-privacy directive demands consent for almost all kind of cookies that are not strictly necessary for the functionality of the website. And our legislation doesn't have this kind of requirement. We could use legitimate interest to process data through cookies for advertising, for example, in my personal opinion. But our data protection authority went to another way, and it said basically that if you are using cookies for something that is not strictly necessary, and sometimes to aggregate data for analytics, you can use legitimate interest. But for other reasons, you should use consent. It's of course it's a guideline. It's not mandatory. You can build your own answer to this question. But this is the main understanding that our authority have published about cookies until now. You asked me about examples, real life examples about cookie compliance. Companies are kind of applying what our authority bring to us. So what we are seeing is the majority of our websites is collecting consent for all the cookies, and we have like the same problem that we had in Europe with the consent. I don't know if the right answer in English, but it's like when we are tired about cookie banners, we are tired to have to accept everything. But this is what is happening here. I believe that the companies are worried that if they are not using consent, their data processing activity related with that is not in compliance with legislation. So this is the first real case. All the companies are using consent as the main legal basis to process data through cookies when these cookies are not strictly necessary. Another thing that is interesting is that we don't have a direction or a formal opinion from our DPA or even a guidelines regarding dark patterns, but we have indications that we have to, if you are collecting consent, we have this consent have the same requirements that the GDPR consent. So it should be free, it should be freely given, informed, unambiguous. So because of that, for example, a few techniques of dark patterns, like big buttons with accept and a small one with refuse, is not forbidden, but is not well received by our authorities. So the companies are trying to use this like the regular ones, like refuse and accept, and in the same size, it's the same color, trying to avoid this perception that we are trying to apply dark pattern here to guide our users to give their consent to us. And the third part of what I'm seeing the reality here, how companies are dealing with that is the quantity of layers that are applying to the until you can reach a price notice. There's a recent decision in a enforcement case by our DPA here, not related to cookies, but in this decision, our authority addressed it a little bit about transparency. And one thing that our authority understood in this specific case, that it wasn't in compliance with the level of layers that the data subject should pass through to access the price notice. So in this specific case, the link to the price notice was very small, and you barely could see in the bottom of the website. When you click it there, you went to another page explain, okay, this is our price notice, this is our terms and conditions. Then you have to click again to access the price notice. So we have like 3 layers to actually access the price notice. And this is kind of thing that our authority is understanding that is not aligning with our transparency principle. So the companies here, they used to do that before, but I believe that for the future, it will be a even bigger concern to have more clear and direct access to the price notice, and also indicating where your price notice is. Sorry, I have one more that I forgot to mention about consent. In this case that I've just mentioned, there's another thing that is, I believe, that could impact cookies. That is, you have to inform the data subject when you are collecting consent. You have to inform the data subject exactly what you're doing with this consent. So, like broad and generalist explanations, like I use your data for marketing. This could be be enough to address transparency requirements. So you have to inform and use this data to deliver behavior advertising or advertising based on your online activity, for example, something like that. I'm not sure that this is you address, but something around this, because like general purposes could be not enough to fulfill the requirement of the consent being informed. And I believe that this basically address all the how companies are addressing this cookies approach, being more transparent, avoiding dark patterns, and asking consent for everything, which personally I believe that could be more flexible, but not right now without a proper guideline or proper enforcement action from our data GPA is the basic approach that companies are using here.
Very good. Well, Barak, I want you to tell me a bit more about best practices in Turkey and focusing on some of the consent management challenges, and also maybe some of the differences between what you're doing in Turkey and what's happening in Brazil.
Thank you, Debbie. Since we are a cookie management platform, consent management platform, this is our main focus, main area. So we are actually always up to date about what's happening around cookies in Turkey. So what I can say is, which is something that is really missing in our country currently, the data protection governance, from a governance perspective, the number of public decisions are very low. So each year, our Turkish DPA announce how many decisions that they came up with. But the announced and public decisions are a very small fraction. So we have 3 or 4 maybe cookie-related decisions at the moment, public. So that's why we are not 100% sure how Turkish Data Protection Office authority would respond to several ad hoc issues. However, likewise in Brazil, Turkish authority also published a guideline about cookies. So when it comes to the user experience, user interface level design, we can see that there's a template, a 3 button template with no hierarchy among the buttons, all same color, just like Henry advised. However, Henry, I noticed that in Brazilian guideline, there are not 3 buttons, only 2. And I think it is also the case about the implementation as well. But anyways, in Turkey, we have a 3-button system. So when you see a 2-button option in any website, it means that generally the data controllers, the publishers, take some kind of legal risk for the sake of some commercial or any other benefit. That's for sure, because the guideline is very clear about this. You have good practices and bad practices, and good practice is 3-button approach. But in the meantime, I'm also very I'm very curious about Henry's reply to what I'm gonna say now. In Turkey, we have also some sort of data residency issue as well, besides the design. So this is the interface, user interface side. We have 3 buttons. That's with the same hierarchy. That's okay. But when you look at the system side, backend side of things, generally the data should be residing in Turkey. So the servers of that information, personal data, should be residing in Turkey. If not, before 2024 changes in our law, it was bound by consent only. But now we have a GDPR similar structure. There are a lot of other options, but the main options that everybody use is standard contractual clauses that was advised by the authority. So when you see a cookie wall, let's say, cookie banner, the data that has been collected through that cookie banner either should be residing in Turkey or if going abroad out of Turkey, then it should be the company, if it's a service cookie management platform like Efilli, CMP like Efilli. If there is a service, the service providers servers should be either in Turkey or they should have a standard contractual agreement with that CMP provider. So I'm curious about how it is in Brazil, Henry. Is it also similar regime or different?
That's a good point, Burak. As I mentioned, our data protection authority just have one guidelines regarding cookies, and it's like a short guideline, like that 15 page. It's not something that does cover a lot of situations. And we have like a image of ideas of best practices on how you could present your cookie banner and how you could present your buttons, etc. But there is a room for other practices, not like you cannot use another way. You can. There isn't like a lot of examples of bad practices. It's more focused on this is the general idea of what you have to do, but it can work in the room that you gave you about that is not exactly that I'm showing you. And this is the first thing that I want to mention. The second one is we don't have data localization requirement. We did have international data transfer requirements. So that was like brand new regulation that we had from our authority. It was published in July last year, and you enter into force this next July. So it's not being applied yet, and it's very similar of we have in GDPR. So you can use standard construction clauses, which is the standard practice for the companies. You can use BCRs, you can use specific clauses, and BCRs and specific clauses, of course, should be approved by our GPA. So we don't have like the data localization, and we don't these three buttons practice that you mentioned. I thought this is really interesting. We don't have this here, but it is a practice that I forgot to mention that companies are doing. So, for example, we have the accept button, the refuse button, and you have like the accept button and the customize button. So you have to click this one to say which cookies you want to refuse. I don't think that this is the spirit of the guidelines that our data protection have published. A lot of companies are doing this, but I believe that this could be a problem if our data protection starts to enforce these guidelines. Because of course you are making more difficult to the data subject to say what he really wants and if they want to refuse. Because I have to click a button to select the cookies that I want to refuse, to click the refuse button, to save that preference, and then back to the website. So it's kind of a lot of steps that I have to take to refuse the use of cookies. But a lot of companies are doing that. And as you mentioned, they are taking, in my opinion, they are taking a little bit of a risk here. But there is another thing. In the worst case scenario here, you have two options probably if enforcement action started against your company. The first option is to exclude the data that you have collected through these cookies without the proper consent and change your website, or keep in the way that it is before. And you have time to adjust your practice, which means that probably this enforcement action will not result in a fine, and probably more in a I forgot the name in English, but like a notice from our DPA, and like maybe just a recommendation, because you can't even if you exclude the data, the behavior advertising was already delivered for you, and this data, as you know, all the ecosystem of ad techs had access to this data before, so it's kind of what you have to do with the data was already done. So yeah, I think that is. I addressed your question, Brock. Sorry, I start to open a lot of parentheses here, and I didn't know if I addressed your question directly.
Data localization. I think it is not as strict as Turkey was.
No, it isn't. It isn't. Yeah.
So it is more liberal, let's say.
Yeah. But one another take that I think that is interesting is that as I believe there was the French authority, I'm not sure if it's the French or the Spanish authority that have applied a fine to Google because the Google Tag Manager used to transfer data to US using standard contractual clauses. And the French or Spanish DPA said that this wasn't the best way to do that. The SECs wasn't protecting the data because the legislation in US could not help the SEC to protect the data because a few legislations allow government to access the data without like a proper warrant or without a legal base. So they fine Google for that. And I believe that the same argument could be made by our data protection authority because we have the same rules again regarding SECs, and we have the same rules regarding be sure that the receiver of the data have a legislation that will not conflict with the SECs. So it is not just to say that we are not restricted as in Turkey, but it's not as easy as could be. Sorry, it's not easy as we imagine because sometimes if you don't use the correct data transfer mechanism, this could be a problem, as we said in this case in Europe.
Yeah, very good. Barack, I want to know, are there either notable cases or enforcement in Turkey, outside of Turkey, that you're looking closely at right now?
Yeah, we are currently. I can say, like as I mentioned earlier, there are only 3 or 4 cases that can be relevant with cookies or tracking technologies in Turkey. So as our Brazilian colleagues do, we also look at the European cases more than we do on our own. For example, there is one in France. By the way, French Data Protection Authority is a leading authority in Europe right now in terms of cases and decisions. So they pretty much create the space by their own. It was ICO before UK's exit from EU with their let's say documentation, proper documentation. But now it's French, and they issued a lot of decisions. They reached a lot of decisions about how to use cookies and how to track users through that cookies. A few of them are famous Google case and some other cases as well, like that. CNIL's case. CNIL is abbreviation of French authority. Anyway, but I can see that the other authorities are also active. For example, a month ago, something like that, Swedish authority gave a decision about cookies. So we always follow these decisions. But what I wait and what I think would be the next step is the mobile ecosystem, because generally what the general public think that the web apps, the websites are generally the one that is in frontier, but actually we are getting into an era where the mobile apps would be more important than what we have in the regular desktop web apps. Because right now, when you check the e-commerce trends, when you check the general internet usage trends, you can see that mobile trend is booming. So the focus of DPAs will soon turn to the mobile domain, and we will see more decisions about the mobile app consent and tracking technologies more than, I think, web apps in close future. So this is what I foresee.
I think that's true, very much so, because the mobile ecosystem is very it's kind of a tight ecosystem. So there's a lot of data or a lot of interplay between different apps on phones, and you can tell a lot about people based on those apps, right? And so companies they want apps, right? Because they can get more data than they could just by you going to their website and clicking on their website. And that's one of the reasons why Apple did their app transparency thing to opt people out of marketing, because what a lot of these app companies were doing was, not only gathering data about your use of that app, but they can, stuff that you would never think about, like how much money do you spend in the app store? Like you would never think that they would need to know that across apps. So I think that I agree. I agree that that will be something that will be very big in the future. Well, Henry, I want your thoughts. Obviously this is a global audience, and I want to talk a little bit about some of uh, the global compliance strategies that companies need to think about. So we know the companies are all over the world. They have maybe consumers all over the world. What are some of the big things that you think companies need to be thinking about as it relates to cookies?
Yeah, this is a big challenge because all the companies or the companies I deal with usually want to simplify their privacy programs or compliance programs in general. They try to use the same processes, the same rules, the same policies for all the countries because it's easier to control. It's easier to be sure that we are aligned to business objectives, business goals. So this is what companies usually try to do. And unfortunately for privacy, this is possible because as for example, Brock brought up information that I didn't know about data localization in Turkey is something really hard to comply with. You have to find someone, a service provider that you store the data locally and it is compatible with the other systems that you use. So all this kind of stuff is really challenging. And I believe that for cookies, this is probably what I'm seeing and what companies are doing in the sense of simplify things is to use consent for everything because it's hard to imagine a legislation in any country that will forbid consent to collect cookies. So what companies are usually doing is, okay, I will ask consent for everything, and especially for multinational companies. What I see here from Brazil is that usually you have a lot of it's really hard to have a specific privacy notice for Brazil or a specific consent management system for Brazil. Usually, the companies usually use global solutions, and they want to standardize their privacy notice and the language used in privacy notice. So when you use a baseline legal basis to process this kind of data, it's easier to build your processes. So this is what I'm seeing. Companies are relying on consent, and I believe that as Burak mentioned, it's easier to be more precise on like the language that you use in the cook banners. Have an accept button, a refuse button, or a customized button, for example, to be more fair in the way that you deal with these options for the data subject. The availability of the pricing notice, like in a link in several languages. So this is what I'm seeing that the companies are usually doing to try to comply with the most laws that is possible with just one kind of practice. But I'm also seeing that when this is here, but when this approach doesn't fit for all the regulations that we have, they usually before they start to thinking about personalize their program or their practice for that specific country, they are trying to understand how this data protection is enforcing this kind of stuff. They are doing this a lot. They are doing like enforcement actions, inspections for companies generally, or just focus on big techs, for example. Okay, I'm not TikTok, I'm not Instagram, I'm not Meta, I'm not Microsoft or something like that. So I will do this way because I'm pretty sure that nobody will knock on my door saying that I'm not in compliance with cook regulations or cook best practice. So this is also a reality. When the companies see that, they try not to change what they are doing globally. And I see this in Brazil also, companies doing that, which is reinforced by our data protection supervisor or data protection authority behavior. They are not enforcing this kind of guidelines in general. They are not doing inspections in websites like in a I don't know how to say this in English, like looking for a lot of companies in just in one shot. So they are doing this. I have a compliance claim here, or I have a data subject that is not being able to request their data or to perform their DSAR. So they have a claim open with the data protection authority, and then they will open enforcement action case against that company. So what our authority is showing right now is that it's not a priority. So probably it takes to it's not like it's not hard to understand why companies are taking risk here because it's not being forced. That's the truth.
Right. And I think that answers Hassan's question that he had written in the chat. I have a question here that I would like to direct to Barack. The question is, I came across a cookie used in the Inter-Parliamentary Union website. The privacy policy says Google declares that it complies with the EU-US Privacy Shield framework. Google may transfer the information collected to Google Analytics to third parties where required to do so by law, or where such third parties process information on Google's behalf. And the question is then, does the consent of the users entering the site have any meaning, and how is it possible for them to do this?
The data exchange between US and EU has always been a big challenge because the way European, let's say, legal framework looks at the data and how it should be transferred is not the same in US. Since Debbie is here from US legislation space, she will just, like maybe add some extra on top of it later. But what I know is from the two Max Schrems cases is that still the European level of protection is not the same in US. So all this general, let's say, efforts to put this transfer scheme into a proper box always fails due to this different mindsets. And that's why I can say that this is a fine print. Generally, the transfers are not the same as transfers within, let's say, jurisdictions that has adequate level of protection.
Correct.
That's what I can say.
Yeah, I guess at a high level, this first of all, this is a big question.
Yeah,
But
this is another webinar, by the way.
yeah, so I'm gonna give you like the really short version of this, the answer. So in the US, we have basically two levels of privacy protection, probably more, but just for this this question, I'll say there are two. Okay. So one is the consumer level, right? So US, we don't privacy is more of a consumer right. So as you're, utilizing different things, you have certain rights. And then there's this upper level, right, where it's more around national security, terrorism, the country's ability to do different things. And so this is a huge big tension between the US and the EU. And this goes back to some of these Schrems cases as well. And the problem is that those two basically don't meet. Right. So if you're a company, you're a multinational company, someone from the US, like a law enforcement person comes to your company and say, hey, give us this data, they're bound by the laws of the country that they're registered in, right? To be able to give that data over. So your consumer right will never trump the right of, these agencies. And that's this has been going on for like 30 years. This argument about a person's right, and I think in the digital age it's just getting more complex. So that's my answer. So let's see, we have something here for Henry. Henry mentioned that the Data Protection Authority is active from 2021, and the published their guideline for compliance and cookie data processing. I want to ask how the ANPD audits cookie compliance. Is there a common penalty, sanctions, non-compliance for guidelines or to guideline?
This is actually a question easy to address because our data protection authority is not enforcing this yet, at least not yet. But I, as a lawyer, I can say that if they start to enforce this, we have to have means to prove that we actually have a way to manage consent if the consent is the legal base being used to support this data processing activity. And sometimes this is the tricky part, as Burak mentioned before, because if you don't use a proper consent management platform, it will be very hard to produce this kind of evidence to show to the data protection authority. But saying that, as I mentioned before, there isn't, at least right now, there isn't any specific enforcement action regarding cookies being carried out by our data protection authority. What we have is other topics being in the focus of our data protection authority, and the part of cookies or consent management is part of the problem, but it's not the problem itself. So as I mentioned before, when the our data protection is looking for this kind of stuff, they are more worried about privacy notice deliver, the layers of interactions that you have to go through to access the information about what we are concerned with and how your data is being processed. So this is how our data protection is approaching this problem right now.
Excellent. Well, we're about to wrap up. I would love for start with Henry. If you give maybe 1 minute follow-up to let people know maybe some last words or some takeaway that they should have from this session.
Well, I have to start with thanking you and Burak for this webinar. Burak is a great friend from IPP. And Debbie, I hope I could meet you personally in the future. So thank you everyone for your audience right now. And my last words is transparency and the way that you perform consent collection is the key here. If you do this in a way that is clear for a data subject of why and with for why and what you're doing with their data in the moment that you're collecting the consent, you are probably good with our regulation and also providing fair options for the data subject, like the refusal of the cookies, the personalization of the cookies without a burden to the data subject to actually be able to customize how and which cookies he accepts to collect its data.
Excellent. And Murat, your words?
I would like to thank both our panelists from America's North and South. So thank you for sharing the screen with me. It was an honor. And I'm very much informed about the cookie regulation in Brazil right now. I was not like my level quadrupled with this webinar. Thank you, Henry. And great questions from the audience. Debbie, thank you for the moderation. Perfect, as always. Data Diva did the job. So what I can say is, personally, I love data protection privacy space, and it is always evolving. In terms of Efilli, we love also serving our beloved customers in terms of their data protection on their way to data protection compliance. We are not a compliance enabler. We are a compliance partner where we help them reach compliance. So cookie consent management is one of them. Henry, I know that we will be seeing each other in Brazil this year. I'm sure about this.
For sure. You'll be a pleasure.
Okay, let's do some good Brazilian coffee then.
For sure. Coffee, feijoada. Why not
All right,
caipirinha?
all right. Why not?
Excellent.
Why not?
Excellent. Well, last word, I guess Data Diva gives it. Companies need to really think about that transparency and putting the customer first as they're thinking about this, and then also figuring out the complexities, right? So it is complex across different jurisdictions and different geographical regions. So I think it's just going to be a hot issue continuing, and we'll continue this discussion in the future. So thank you all. Bye-bye.
Bye bye.
All right.